So, what exactly happens to literally everything you own the precise moment you pass away? It's a reality we're all going to face, right? But the actual legal mechanics of it, well, they usually remain a total mystery to most of us.
Welcome to This Explainer. Today, we're going to demystify the complex rules of succession. We're translating strict legal codes into a super accessible guide. I am so thrilled to walk you through this incredible architecture of estate law, mapping out exactly who gets what and, more importantly, why. We've got a clear roadmap for today. We'll hit 1. The basics of succession. 2. When there is a will. 3. Dying without a will. 4. Rules for all heirs. And finally, 5. Dividing the estate. All right, let's jump right into part 1, the basics of succession. Now, under Articles 774 and 712 of the new Civil Code, succession isn't just about handing over the keys to a house or passing down a bank account. It's actually a comprehensive transfer of a person's entire legal and financial footprint. We're talking all rights, obligations, and properties transmitted to another person through one specific event: their passing. This whole process requires 4 precise elements to actually work. First up, it starts with death, governed by Articles 775 and 777. That is the operative act that immediately transmits rights. Next, you have the inheritance itself, basically the estate, under Articles 775 and 781. Then you need the successors, or the heirs, defined in Article 782. And finally, acceptance, covered by Articles 1041 to 1057. Now, acceptance is a purely voluntary act. You don't have to take it, but here's where the legal magic really happens. Whether an heir accepts or repudiates the inheritance, that decision actually retroacts. It reaches all the way back to the exact moment of death. So legally speaking, there is never, ever a gap in ownership. When we talk about successors named in a will, we need to draw a line between 2 terms: devasees and legatees. Devasees are folks who receive real property, like land or a building. Legatees, on the other hand, receive personal property. Think a vehicle, jewelry, or cash. Grasping this difference is totally foundational to understanding how specific gifts are handled down the line. Moving on to part 2, when there is a will, this covers testamentary succession under Articles 783 through 959.
The law explicitly defines a will as a strictly personal act. And what that means is you absolutely cannot leave its creation up to a third person. You can't just scribble a sticky note telling your best friend to sort out your estate. No way. You, the testator, have to formally control where your property goes, following the strict formalities prescribed by law.
But here is the biggest plot twist in succession. A will doesn't actually give you absolute freedom to do whatever you want. You can't just leave your entire fortune to your neighbor because the law fiercely protects something called the legitime. Think of the legitime as a locked-in, reserved portion of your property meant exclusively for compulsory heirs. That includes legitimate children, parents, spouses, and illegitimate children. The law actually steps in to make sure your closest family isn't unjustly left empty-handed.
Okay, but what if there's no plan? That brings us to part 3, dying without a will, or intestate succession, covered by Articles 960 through 1014.
Here's exactly when these default laws kick in. It's not only when someone dies without a will altogether. Intestacy also triggers if an heir dies first, refuses their share, or is somehow incapacitated. It even kicks in if the will itself is voided, or if the will just accidentally misses some property. Whenever there's a gap, the law essentially provides a safety net to fill it. In this default state of intestacy, everything is run by the rule of proximity. This means closer relatives completely shut out more distant ones. For example, the descending line, so your children, always excludes the ascending lines, like your parents, and the collateral lines, like your siblings. It is a very strict hierarchy based purely on bloodline proximity. Let's look at part 4, rules for all heirs. These are the common provisions found in Articles 1015 through 1105.
Now, this brings up a super fascinating practical issue about capacity. Generally speaking, you have to be alive at the exact moment the succession opens to inherit anything. So, what happens to those slices of the estate pie that are left behind if someone refuses their share or dies before the testator?
Well, thanks to the right of accretion, that abandoned slice of the pie doesn't just vanish into thin air, and it doesn't go to the state either. Instead, it's immediately added or incorporated into the shares of the remaining co-heirs. The law really prefers to keep the property consolidated among that originally designated group of successors. We also have the right of representation. This is a really powerful legal fiction that allows a child to step up into the shoes of a deceased parent to inherit their share. But the crucial catch here is that in the direct line, this only works downwards, in the descending line. So a grandchild can represent a deceased child, absolutely, but a grandparent cannot represent a deceased parent.
All right, for our grand finale, let's dive into part 5, dividing the estate.
So legitimate children and descendants have that strictly protected legitime we talked about, and it always equals exactly 1/2 of the hereditary estate divided equally among them. The remaining half, that's considered the free portion. But that first 50% is legally locked away, completely safe, for the legitimate children.
Now, the surviving spouse's slice actually shifts dynamically, depending on the children. If there is just one legitimate child, the spouse gets a quarter of the total estate. But if there are 2 or more legitimate children, the spouse's share becomes perfectly equal to one legitimate child's share. This formula basically ensures the spouse is taken care of alongside a growing number of descendants. When we factor in illegitimate children, the law applies a strict 2-to-1 ratio. That means an illegitimate child's legitime is exactly half the size of a legitimate child's share. However, there is a very strict condition. Taking this share absolutely cannot impair or eat into that locked-in legitime of the legitimate children we just established.
What about parents and ascendants? They are essentially fallback heirs. They only get a half slice if there are no descendants at all. And if those primary bloodlines aren't around, then collateral relatives, meaning brothers, sisters, nephews, nieces, and cousins up to the 5th degree, can legally step up to the plate to inherit. And finally, we hit the stark reality of estate law. If absolutely no qualified relatives exist, I mean no descendants, no ascendants, no spouse, and 0 collaterals up to the 5th degree, the state steps in and inherits the entire estate. Understanding these strict rules of succession really gives you the power to decide, because if you do nothing, the law has a very rigid default plan waiting for you. So, what steps will you take today to ensure your legacy ends up exactly where you want it? Thank you so much for joining me to break down this incredible topic, and I'll catch you in the next explainer.